Is the FTC going to use a law, Coppa, that's been in effect since 2000 to suddenly come in and fine content creators on YouTube $40,000+ per video? I mean, maybe, but will they win? That's the real question. I don't think so, and let me tell you why. Hey, what's up, guys? I'm your host, Nick Rekieta of Rekieta Law, a small law firm in central Minnesota, and obviously a giant nerd if you're not familiar with the channel. Both of those things are true, lawyer and nerd. Oh, and small town Minnesota, all of that stuff. Recently, an FTC director came out and made some statements in light of the recent settlement that YouTube had with the FTC and with the state of New York over this law, Coppa, the Child Online Privacy Protection Act. This is a law that was passed in like 1998 and has been in effect since 2000, regulating the way that internet websites collect data on children 13 and under. Or rather, don't collect data on children 13 and under. If you notice, a lot of websites like Twitch and Twitter and YouTube and Facebook and all of these different sites have restrictions on children under the age of 13, and that's because of Coppa and how difficult it is to not only manage their data in a way that complies with the law, but also to provide adequate disclosure and to obtain something called affirmative consent from parents to have the data collected and stored, and also allow the parents to review it. It's just a mess. It's a huge mess. The goal of the law was not to provide a framework for data to be collected. It was to provide a framework that was so arduous for the website that they would just forego the collection of data altogether. The government got together and said, we don't want kids' data to be stored by these companies. Why? Who knows why Congress does anything, but for the children is always the perfect reason. But this has all been fine and dandy until very recently. YouTube settled with the state of New York and the FTC for a total of about $170 million in fines because they were, as it turns out, collecting data under the statute on these kids who watch YouTube. They didn't even have to really create a YouTube account to do so. I mean, just by merely viewing YouTube on a device as a child, even anonymously, YouTube is still collecting and using that data and may use a tracking cookie or something attached to that device, and that actually falls under the statutory definition of collecting data. So YouTube was fined, and rather than fight it out and tell the FTC to shove it, and the state of New York, who really does need to shove it, what they did was they settled for $170 million combined, as I said before. And as part of that settlement, they're implementing a whole slew of new rules. I'm sure you've seen 100 other YouTubers talk about this, talk about all the new rules and how we now have to designate whether or not our video is directed towards children, whether or not YouTube can show it to kids at all sorts of things now that we do to help YouTube manage content that is aimed at children rather than adults, or aimed at adults rather than children. None of my content is directed at children. I don't think most kids want to watch a bunch of legal explanations punctuated with a pound of profanity. Like, they just don't typically want to do that. So I get off this pretty easy. But other content creators have different types of content that might look like it appeals to children, even if they're not specifically directing it that way. And the way the FTC kind of determines if it's directed at children is very arbitrary and stupid because a government made it, right? Specifically, our Congress. Our Congress in 1998, forward-thinking visionaries that they are, figured out how the FTC would determine if it's kids' content or not. And since they apparently hadn't heard of hentai yet, they're like, cartoons. Only kids watch cartoons. Only cartoons are directed at kids. So that was enough. There's some other criteria too, but it's all very vague, and and you know the person doing it is an idiot because government employees just tend to not be very bright about some of the things that they do. Not all of them, but if you've ever stood in line at a DMV, you've probably wanted to claw your eyes out, okay? We know how this works. But the question is, does some disaffected random government employee have any idea what the content creator's intent was by just looking at like channel art and the presence of a cartoon, the presence of music, for example? Does that actually determine how this works? Well, no, of course it doesn't. Of course it doesn't determine the intent of the content creator, whether this is directed at children or not. It's just an arbitrary set of rules that they've imposed. But again, this has all been going smoothly aside from YouTube's little hiccup where they had to cough up a bunch of money because YouTube, not content creators, but YouTube itself, was collecting all of this data and using it as part of their machine learning algorithms, as part of their advertising schemes. Everything that they're doing to generate revenue relies on this data. Part of that settlement was to agree to create these new processes to kind of offload some of that burden onto the content creators themselves. And in the mix, an FTC guy, Andrew Smith, I believe, very, very, definitely not a glow-in-the-dark name there. Andrew Smith went ahead and made this very wonderful statement. Here you go. We would have strong penalties in future cases against content creators and channel owners as well, particularly when we would have a situation where the channel owner was specifically asked, "Are you child directed?" and the channel owner said no. This concerned everybody on YouTube. They're all very concerned now because, if you don't know, an FTC fine under Coppa could be up to something like $42,500 per infraction or per video. So if a channel's got 100 videos, we're talking millions of dollars in fines being put on the table for this alleged rule violation. Now, that's an extreme version, but we have to go to extremes because the law always ends up on the extremes. So how is the FTC going to do this? Can they even do this? Of course they can. The government can do. I mean, cops can charge you tomorrow with something you didn't do, but will they win? And what'll happen if they lose? Those are the questions. I don't think they'll win. Not at first. It would have to be particularly egregious. We're talking the stuff that Coppa exists for is stuff like Elsa Gate, if you remember that, where they had like purportedly frozen characters, but then they had a bunch of not for children stuff going on in the videos. And the whole idea was to dupe children into watching these videos that were not actually appropriate for them to be watching and all of that stuff. I mean, you know, never mind any personal responsibility in any of this. Just forget that that exists. Forget that that exists. But that's the type of stuff this is aimed to remove. And so what they might be able to get away with is if someone created content that looks like it was supposed to be directed for children, actually clicked that it was to be directed at children, and then it was, you know, some sort of like softcore pornography or some other content that most people, that a reasonable set of people would generally agree is not for children. You know, like a cartel execution videos or something, right? Like they don't want kids watching that on accident, and no one wants that to happen. I shouldn't say no one, but most people don't want that to happen, right? That's what this is intended to sort of get around for content creators. But that's weird because that's not actually the purpose of the law. The law isn't about preventing kids from seeing things that they shouldn't see. You know, that's kind of how it's being implied here by the FTC. The law is about preventing the collection of data from children whose data shouldn't be collected. So there's this big kind of mix-up going on here. But let's take a look at how the FTC actually does this. What is their statutory authority? Because once they do go ahead and find someone under this, they're going to have to fall back on the statute. The statute will be, this is the law. This is the law that Congress passed, and this is the operating language that the government agency is required to use to actually impose the fines that they're proposing to the court. And let's take a look at that. So here is the actual violation language, and let's read through this. Is not too long, but it is a little dry. So this is section 312.3. This is 16 CFR 312 is the Coppa section. But this is 312.3. Regulation of unfair or deceptive acts or practices in connection with the collection, use, and or disclosure of personal information from and about children on the internet. Remember, Coppa is about the info and data that's being collected on the children, presumably and purportedly. So the general requirements, and this is where the language is very important. It shall be unlawful for any operator of a website or online service directed to children, or any operator that has actual knowledge that it is collecting or maintaining personal information from a child, to collect personal information from a child in a manner that violates the regulations prescribed under this part. Generally, under this part, an operator must, and it has a bunch of requirements that they need to go about and do to help prevent the accidental collection of data and all of that stuff. We don't need to read that. We're going to focus on that first line. It shall be unlawful for any operator of a website or online service directed to children, or any operator that has actual knowledge that is collecting or maintaining personal information from a child. Now, on the surface, YouTube content creators are not operators of the website or online service. I'm not operating YouTube right now. I'm not doing anything. I have no control over YouTube. I just upload. I'm a user of the service. Under most definitions, I would be a user of YouTube, not an operator of YouTube. I don't run the site. I'm not a site admin. I can't go in and edit code. I can't change the way the website works in some way or another. I can just merely submit content to YouTube. Content that YouTube is free to remove for any number of reasons or no reason at all. So we've already got a problem in the language. But we get a little bit of guidance on this from the definition section. And the definition section is actually 312.2. That's how laws typically are written. The definition section is first. But it's important to look at what the infraction is before we start weeding around the definition section. Now, here is the definition of operator. The definition section is quite long, and there are a bunch of defined terms. But this is what we're going to focus on because this is what matters for YouTube content creators. Operator means any person who operates, thank you, great job government, a website located on the internet or an online service, and who collects or maintains personal information from or about the users or visitors to such website or online service, or on whose behalf such information is collected or maintained, or offers products or services for sale through the website or online service, where such website or online service is operated for commercial purposes involving commerce amongst the several states or with one or more foreign nations in any territory of the United States or in the District of Columbia or between any such territory and any other such territory or any nation, blah, 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 blah. We're going to skip to the bottom here. It says personal information is collected or maintained on behalf of an operator. This is from up above where it said, or whose behalf such information is collected or maintained, okay? So it's collected or maintained on behalf of an operator when it is collected or maintained by an agent or service provider of the operator, or the operator benefits by allowing another person to collect personal information directly from users of such website or online service. All right. This is the statutory language that they're going to be dealing with when talking about a YouTube content creator and attempting to fine a YouTube content creator. Okay? Let's look at this definition closely. Operator, any person who operates a website located on the internet or an online service. Do you operate the website that you're using? Does the YouTube content creator operate the website? This is going to be the argument. What does operate mean in this case? Does operate mean to run, administer, administrate, create, change, alter, provide for the operation of? Like, does it to make the website function? Is that what it means to operate? Or does operate simply mean to use? This will be the two arguments here. And my argument is obviously that operate means to actually maintain the website itself. That is the obvious definition of this. This is the person who's actually doing the collection, right? Is the operator of the website. YouTube content creators, unless you're a weirdo, aren't actually collecting data on the users. YouTube is. YouTube is collecting that data. Now, they provide some sort of high-level looks at stuff. Like, we get demographic reports and stuff like that in our analytics based on what users provide to YouTube. But I don't know. I don't maintain some archive or some spreadsheet with information about each of the users. I don't know anybody who does. And if they are out there, get help. Get help, Bram. Weird. But anyway, that's not the typical activity of a YouTube content creator, right? We're uploading content and we're offloading all of the advertisement, the negotiation, all of that stuff gets done by YouTube. Like, they're taking the reins on that, and we get a pittance of what they make. We don't bear the operating costs of the website. We're mere users who benefit from our use under a specific set of terms. This is where it's pretty interesting, because it says it is collected or maintained by an agent or service provider of the operator. YouTube is not, categorically is not, an agent of a YouTube content creator. That is not a thing. There is no agency relationship between YouTube and YouTube content creators. And if a content creator like I were to represent myself as an agent of YouTube, I would probably be met with a nasty cease and desist letter very, very quickly. The terms and conditions of use for YouTube generally, and for the YouTube partner program where advertising and all that stuff comes in, none of them include an agency relationship in any of the language. They don't imply it. They don't expressly state it. They don't accidentally create it. None of that happens in any of the language of the contracts that we all sign. We are users of the service. That's what we are. And just because we're called YouTube partners doesn't mean we're actual partners or agents or have some sort of inherent authority over the operations of YouTube. We are not acting on behalf of YouTube, and YouTube isn't acting on behalf of us, because we can't direct YouTube to do what we would want an agent to do. Like, I can't tell YouTube, go out and get targeted ads from this type of demographic. Go out and market me in this particular way. I want you to put my stuff on this channel, this channel, and this channel. These are things that you would instruct an agent to do. If YouTube was your agent, you would instruct them to go do this. And I am certainly not telling YouTube to collect data from children who are 13 or under. I'm not. They're not doing it for me. YouTube does it for them. It benefits their machine learning algorithms, like I said earlier. It benefits things like how they do targeted advertisement. It benefits them in I guess just general demographic and future casting for the website and the operation and the longevity of the business. All of that stuff, marketing trends, everything that YouTube is doing with that data benefits them directly, and it's at their sole discretion. If they stop collecting it tomorrow, I couldn't make them collect it. They do collect it now, and I can't get access to it. Like, I can't demand that YouTube provide me a bunch of stuff. I could maybe ask, and they might give me some info, but they're not required to. We don't have that kind of relationship. So they are not collecting this stuff on behalf of me. I'm not benefiting directly from some sort of agency relationship where this is maintained. Okay, and so then the next section, of course, is the operator benefits by allowing another person to collect personal information directly from users of such website or online service. That's not, I know what they're going to try and do. Like the FTC will try and say, nope, YouTube channel content creators and channel owners are operators, and they're benefiting by allowing YouTube to collect the information from users of the service for them. That's not what this is actually saying. This would be like if YouTube hired a third-party analytics firm to come in and take all of that demographic information and help them develop strategies. Typically, you would see this with a smaller business that is using a third-party company to come in and do this stuff that they're not equipped to do. YouTube is doing all this. This is not directed at content creators on its face. Does this mean that the government won't attempt to use this against a channel? No, it doesn't mean that. But what it does mean is that the channel that it does go after, and it's going to go after probably a big channel first, and it sucks to be that channel, but the channel it does go after will have the opportunity to slap YouTube in the face with this, or well, not YouTube, but the FTC. Will really have a chance to put them back. It will create a giant public uproar because if they go after a big enough channel, like if they go after, a PewDiePie or something like that, they're going to have to answer for the fact that they're going up against someone that a lot of people like. A lot of people like some of these channels, right? You've got millions and millions of viewers on many of these channels that have questionably child-directed content. And when they go after that channel, there's going to be a public discussion about it. It's going to hit the media, and the FTC is going to be under the microscope here. Is this what we really wanted? No, we want to control the websites that are doing this. That's what people are going to say. We wanted to control the websites. We wanted YouTube to be responsible, not these random people uploading videos and doing all this stuff. They are not benefiting from the content that they're collecting, that YouTube is collecting through them, right? It's not collected on my behalf. YouTube is actually utilizing me to collect demographic data for all of you wonderful viewers. And I'm sorry for that. That's just how it goes. But that's what they're going after here. That's why I don't think Coppa is as big of a deal as people are making it out to be. I think it's going to be a while before we actually see a fine from this being levied against a content creator, and they're going to pick whoever's doing it. By the way, it's going to be someone that they will be arguing is doing this in bad faith. That in bad faith, they're saying that the content is not directed at children when it is, and the whole object is for them to get children to watch and get that data collected, but it doesn't make any sense to do so. It doesn't make any sense to do so because the content creator is not benefiting from having that data collected, right? Like if you create a video that is directed for children and you say, no, it's not directed at children, in the hopes that a bunch of kids are going to come watch it, you don't benefit from a bunch of kids coming and watching that content. Because YouTube isn't turning off ads for children's content. They're just engineering it so that the ads are generalized rather than personalized. And so all those ads will be generically geared to target children generally, rather than to target children based on their specific watching habits like they're doing now. So the advertising will still take place on both sides of the platform, the non-children side and the children side. So ostensibly, the content creator is not like gaining something by tricking children into watching on the non-children side, and in fact, maybe hampering his ability to earn ad revenue from lucrative child-directed ads. And that just doesn't make much sense. If you ask me, I don't know, maybe I'm completely wrong on that. But either way, I think when the FTC does eventually do this, and I think it's a ways off, they're going to do it in a way that is going to go after the most egregious offender they can think of. that they can find. They're going to try and find someone who is maliciously targeting children with videos and then labeling them as not for children or something like that in an attempt to somehow gather data. But again, YouTube benefits from that data. The content creator typically doesn't. And that's one of the huge hurdles that the FTC is going to have to overcome. They're going to have to explain to a judge how the content creator benefited from the collection of data that they didn't do on a website that they don't run, and with data that they don't even see and don't have access to. That's going to be their big hurdle. I don't think it's as big of a deal as people are making it out to be. It remains to be seen, but I hope this video has shown you at least the statutory language that they use. It'll help you kind of form your own opinions on what the government can do. I'll tell you that operates the website. That's not a defined term in here. Neither is online service. Online service is not defined. The internet is defined as the internet. The network of computers and hardware used to maintain what is commonly known as the internet is the definition. But they really have a problem with what does operating mean? What is an online service? And the biggest problem is actually in this line here, and it's the word "and." Operates a website located on the internet or an online service, and who collects or maintains personal information from or about the users or videos to the website or online service. YouTube content creators fall apart at the "and." We don't do it. So then they have to do it on our behalf, which means an agent or a service provider, or they have to argue that we benefit from it. And I'm coming back to this because I can't stress enough how weird this "and" provision will be for the FTC to argue to a judge. Because the FTC guy is going to stand up there and say, "Judge, they're doing it on behalf of Ryan as he opens toys. They're collecting data on kids on behalf of Ryan." And Ryan is like 7 or whatever. So his parents and their lawyer are going to say, "Ryan doesn't have access to this data. Ryan didn't ask YouTube to collect this data. Ryan doesn't utilize this data. YouTube does all of it. How is this Ryan's fault?" And the FTC lawyer is going to have to go, and come up with something. He'll have to come up with some weird tangential benefit, but they won't be able to articulate a clear step to the benefit that a YouTube content creator has for the data collected when they don't have access to it, they have no control over it, and they can't stop it, and they don't even know how much data YouTube is collecting. So we can't even notice. We can't even provide notice to parents or the option for that affirmative consent that would be allowed under the statutory framework. Because you can collect all the data you want if you can get affirmative verification that the parents are okay with it. We can't even do that. We don't have the option to turn any of this on or off at all. And YouTube's going to say, well, they could click the button that says it's directed for kids, and then that'll turn it off. Okay, cool. But everybody who doesn't click that button is clearly not intending their video content to be delivered to children. They're just not. So whose fault is it? We can't direct our content to children by saying, no, don't direct it to children. That would be up to YouTube. And again, ultimately, how do we benefit? These are the legal arguments that are going to be happening in the next couple years, I guess. But I think it's going to be a ways out. And I think Andrew Smith is probably just puffing a little bit. Probably just puffing up a little bit about how much authority the FTC has. And I think everybody should calm down. And when we see that first case, we can start to determine then. But otherwise, pretty simple. If you intend your video to be viewed by children, click to have it viewed by children. If you don't. There. Now, what YouTube does is a separate story, and that is a different video. Hope you guys like this. If you do, share it, subscribe, follow, all of that stuff, and we'll see you soon. Peace.